So my name's Michael Legg. I'm an associate professor at the University of New South Wales Law School. My, area of expertise is in civil litigation, and in particular class actions, regulatory and commercial litigation. I am admitted to practice. I was admitted in New South Wales in 1998, and then I was admitted in New York in 2002. And I guess if you tried to sort of say, well, where did you practice? Based on the typology we've seen today, big law would be where I would fit. And so in terms of what I'm looking at today, I'm going to probably discuss two main areas. One is alternative fee arrangements, or AFAs, and what's called unbundling or limited scope services. Now, I've looked at them in the context of commercial litigation because that is my background, but a lot of what I'll talk about is obviously relevant to other areas of practice. And I think it's fair to say that these are areas which have been around for quite some time, but the thing that is probably having the biggest impact today is the technology. That's what's taking these things and making them far more, possible and attractive. So to start with alternative fee arrangements, they're basically a way of charging a fee that is not time-based or the hourly fee. So to be alternative, the alternative is to time-based billing. So legal fees have been charged throughout history in a whole range of different ways, and some of those are starting to come back into, fashion. But time-based billing, or the billable hour, is probably the most used fee arrangement. And interestingly, in doing the research on this area, what I effectively discovered was that in the 1970s, there was a lot of research done in the US and Canada, and they effectively came to the conclusion that the lawyer who records time is consistently a higher earner than the non-timekeeper. And that sort of research and study then was picked up and used by a lot of law firms. So time-based billing has dominated for probably the past 40 years. And so the question is, well, what is it that's changed to, challenge that domination? And I think those things are basically, in business, there's now a greater focus on the results or the value that's achieved rather than the how did you get there. The economic downturn from the global financial crisis seems to have changed the market so that a lot of your corporate clients are trying to restrain their legal spend. Increased competition in the legal market. And I think we have heard today that effectively demand is not growing, and so as a result you have lawyers needing to sort of fight for the existing work. And then technology. So that has commodified some legal tasks, so costs can be more accurately estimated. Or things such as data mining now mean that it's much easier for both a law firm and for their clients to understand their legal costs. And so that means that a law firm can actually look at all that work that they've done previously, look at the bills that they've been rendering, and effectively conduct analysis to be able to say, well, we could actually work out how much it costs to do these particular things. And so we don't necessarily need to charge it by an hourly amount because we know roughly this is what it would be. So as a result, there's now a number of fee models that exist. And just to go through those quickly, contingency or conditional fees, fixed or flat fees, capped fees, collars, holdback or success fees, and then there are modifications of billable hours. Now that's not technically an alternative fee arrangement, but they do get used a lot. So that's discounts that are given to clients or blended fees. The thing to keep in mind here is that whilst we have all these different fee arrangements that could be adopted, there are regulatory restrictions that prevent some of them being used. Contingency fees being the classic example in Australia because they are illegal. And another issue in the litigation space is when you're looking at adopting these sorts of fee arrangements, you've got to factor in whether they're going to work with the rest of the if you like, the court system, the litigation system, which is basically what happens if there's an adverse costs order made, how would that be calculated? Or if costs need to be taxed or assessed, how's that going to be calculated? Then the second area that I was going to talk about is around unbundling. That's basically just breaking a matter down into various tasks with a lawyer providing representation for only some of those tasks. And I think that's one of the things that we're starting to see here with the different models of law that are taking place. Unbundling is not new. Traditionally, it's the way in which access to justice was afforded to people who didn't have the financial means to pay for a lawyer for full representation. And so what would happen is a lawyer would be asked to act on some components. Maybe that's, drafting a pleading, maybe it's appearing in court, and the client would then be self-represented for the other parts of the litigation. Now, the thing that I guess has become, that's happened more recently is applying unbundling in relation to commercial litigation. And the drivers there in terms of unbundling are basically businesses using their own in-house counsel team, what's referred to as insourcing. So the in-house lawyers do more work, and so it might be that they do, the whole transaction or the whole piece of litigation, but it may also be that you get unbundling because they do some of it, and they still use external providers for some aspects, which leads to the next point, which is corporate counsel will utilise legal service providers, sometimes being non-law firms. So this is your technology providers, because they've got an advantage in cost or expertise, and so they can undertake specific functions either better or cheaper than the traditional law firm who might have done the whole end-to-end piece of litigation. So when you start to look at those legal services providers, that includes your virtual law firms, so your online legal services delivery, or providing the access to the network of lawyers, barristers, and the issue that's arisen there is in relation to direct briefing, and then your document management firms, who primarily are used for discovery. And the area that I guess has sort of captured attention is offshoring, the idea that you may in fact take the discovery or the document management and actually use a provider that's based in another country. So that's my sort of introduction, and I'm happy to take questions.
Thank you. In the context of litigation, what are some of the examples that you've come across of alternative fee arrangements?
Well, I guess the first thing to state is that you need to try and make sure you match your fee arrangement to the particular service that's being offered. And things can go wrong when you get that match is not done correctly. And so if you were to say, well, we can do a flat fee in relation to litigation, then that needs to be a piece of litigation where you're pretty clear as to how it's going to play out. If you use a flat fee and the next thing you know, the piece of litigation's going off in all different directions, parties are being added, it's not going to work. So flat fees can be used in litigation where you've got something which is fairly knowable. So generally that tends to mean pieces of litigation that are that follow a fairly set path. And so typically you're smaller types of matters. But in litigation, conditional fees are obviously allowed in Australia, and so they would be used a lot in relation to, say, personal injury type litigation, class actions. You do see the sort of capped fees being used in litigation. The idea that you're still going to bill on an hourly basis, but you're not going to go above a particular amount. And then the one that I think is in some ways the most helpful if you're trying to move into these alternative fee arrangements is the collar. And the way that the collar works is you'll have a capped fee, but you will have an arrangement that if you actually do the matter for less than the fee, or it actually ends up costing more than what you've capped it at, that overrun or underrun is shared with the client. So if you do it cheaper, then you only get a portion of the amount between what it actually cost and the cap. But if you go over it, the client will say, well, if you go over by, say, 10%, will you bear that? But if you go over by, more than that, we'll pay a portion of that so that you're not completely out of pocket when you've needed to do that additional work.
So is there a future for time billing in the context of litigation?
I think the answer is yes, and the idea that time billing is dead is grossly exaggerated. It's more likely that it's going to be one of the options along with others. And I think the thing about time-based billing is you can replace it the more you understand the service or the piece of litigation. And so that's why if you're able to do the data mining, if you've got unbundled services, it becomes easier. But if you've got a large, complex piece of litigation and, it's very hard to be able to say how many parties are we going to end up with in this piece of litigation? Is this, are we going to be able to resolve it relatively quickly, or is this going to go all the way to a trial? Maybe there's novel legal questions. We could be looking at appeals. Then it's very hard to use something that's capped or a fixed fee. You could try and do it in parts. So the sort of to step back from the larger fee would be to say, look, we can take it to the close of pleadings for this amount. And that might be able to give some certainty to both client and to the lawyer. But I don't think time-based billing is gone. But of course, it all really comes to, what's the horizon we're looking at? Maybe in 10 years' time, the technology will be such that you won't be needing it.
Is this the same experience overseas?
Yes. So I think it's fair to say that there's probably been more experimenting with alternative fee arrangements in the United States. And in some ways that's because there's less restrictions on the way in which they can set up their fees. But Australia has had some innovation, and some of it may actually be linked to the rise of litigation funding. So when you think about, there's a category of fee called holdback or success fees. So the idea being that you're going to be paid a certain amount, but you only say 15% or 20% of what you're going to charge, you only get if you win. Or alternatively, you're paid your hourly rate, but if you win, you then get an additional 20%. And that's what litigation funders have used in their funding arrangements with lawyers. And I've seen both of those used. And so once you see that being used by the funder, you can then see the lawyers themselves deciding, maybe we offer that directly to a client.
Have the courts adapted to dealing with alternative fee arrangements in the context of assessing cost orders, or have we not reached that stage yet and they're still looking at the traditional model of time recording and assessing on the basis of time recording?
My understanding is that the courts haven't had to deal with that at all. And indeed that is one of the challenges, is because if you're used to trying to examine costs in terms of, well, was this a reasonable hourly fee? Was the total number of hours here reasonable? If you're then told, well, it was just a flat fee, and you've got somebody who's saying, well, the amount was not reasonable, how do you assess that? Because that's a very different sort of analysis. And so one of the things that may arise would be whether you have to sort of have both systems running in parallel to try and be able to satisfy a court, this was a reasonable fee. If we charged an hourly rate and recorded all of our time, it would have cost this.
So keep recording on a time basis, notwithstanding that you've agreed a flat fee?
Well, yes. Yeah.
I suppose once the market establishes more in that respect, though, we probably have precedents for costs, I suppose.
Well, I think
certain things are likely to cost, historically have costed around X dollars. So do you think?
I think that's right. I think as you saw people getting more experience with it, there would then be benchmarks that could be referred to. And I mean, the interesting thing is, we used to have scales of fees and things like that in relation to litigation, and that would be what you would look at. But of course, they've been abolished in many jurisdictions.
So I suppose for a solicitor to embrace this well, they'd really need to develop the art of scoping, I suppose, and being very transparent with clients around when there's scope creep, and I suppose project management as well. What would you...
No, I think that's exactly right, is that for these things to work, you really have to have a very clear idea of what it is that you're undertaking to do. And so that means, I guess, being very clear with the client as to what it is that you're doing. And it also means having a very good understanding of how your own practice works, because you need to understand what generates costs and ways in which you might be able to control those costs. So when you see firms using, say, fixed fees, often what that will mean is they'll go, well, we know we can charge this amount. For us to be able to get the real benefit out of that, we want to try and use more junior lawyers because they're not as expensive. But of course, then they've got to be very careful that those lawyers are at the requisite level of expertise, experience to get the matter done correctly. So it's both knowledge of what the client wants, but also knowledge of your own operations and how they work.
So it requires much more of a sort of business management kind of skill to be brought into the mix as well.
Yes, I think so. Because at present, under a billable rate, you effectively, all the risk is on the client. You do the work, you record the time, and the expectation is that they will pay for it. Whilst here, if you're being told, well, this is the amount you're being paid, you have to manage how you do that work so as to make it profitable for yourself.
Just looking at a link between unbundling and the topic I was asking about before, how the courts adapted to dealing with alternative fee arrangements. In a scenario where there is an unbundling of services, again in the litigation context, where the private law firm is doing some of the work and the in-house counsel is doing some of the work, have the courts looked at how you would then, have the assessors looked at how you would then assess the costs that have, part of which have been incurred by the in-house counsel? Or does that mean in-house counsel are going to have to keep time record all their time?
My understanding is that courts haven't looked at that. And that's actually a very interesting point, because there is a general approach, which is self-represented litigants can't retain their costs. And so you may ask, well, if you're the litigant and you're doing the work yourself, can you actually recover it? Because the general rule would be no. So you would need to, be able to try to establish that, in some ways, I guess it comes back to the way that you look at in-house legal departments, whether you're trying to say, well, they are in somehow independent, they are providing legal services to the company, and see if you could get around it that way. But that may, in fact, be quite a hurdle, because as the law stands at the moment, you can't recover that.
In the context, again, of unbundling of legal services, what has been the experience overseas in terms of law societies providing guidance to their members? I understand the UK has done that. You might just elaborate on that?
Well, I think the unbundling creates some, there's some ethical issues for lawyers, and there's also some issues around exposure to claims for negligence. And that comes from the fact that you have to be very clear about what you're responsible for. Because if you're only doing part of the matter, you're not necessarily going to see all of the issues that might be arising. And so if something goes wrong because you were operating on the fact that you're only, you're preparing the pleadings, you talk to the client, but then you step out. And then decisions are made later on, and it turns out that you haven't included something in the pleading, then it might be a case of, well, is that your responsibility because you were doing that? Or if you've been involved in the whole matter, you would have been able to, because if we're thinking of like self-represented litigants, you may have gone, oh, well, we would need to amend those pleadings, and I would go and do that. But your self-represented litigant doesn't do that because they're not aware of that being an option. Then the question is, well, who's responsible for that? Is there a claim against the lawyer? And so the ethics advice that's often given is about making sure you are very clear on the scope of what you're doing and making sure that the client understands, you're taking responsibility only for this particular part of the project. So the United Kingdom, they put together, I suppose it's a sort of a practice note, which really focused on where the unbundled services were being provided to self-represented litigants, particularly in sort of like family law type cases. And that was driven by this concern that practitioners are, they're trying to do the right thing and help people out to the extent that they can. But then when it doesn't go as well as the client wants, they then turn around and sued them. And so this was about trying to provide guidance around that. But that concern is not new in Australia. The Australian Law Reform Commission, in its Managing Justice report, I think in 2000, raised exactly the same issue. And in the research that I did, the New South Wales Law Society's Law Society Journal was publishing guidance around this sort of issue around, I think, 2000, 2003, saying to solicitors, you've got to be very careful about how you do this. Make sure you're very clear on the scope of what the service is that you're offering.
Do you have a handle on the trend for the unbundling of legal services? Is it on the uptake? Has it plateaued? Where is it at in Australia or New South Wales?
Well, I tend to think that it's going to be growing because it sort of goes hand in hand with the rise of your virtual law firm, the technology providers, because if you think about any sort of litigation where there's a relatively large amount of discovery, there's going to be an external provider used. And so that is a form of unbundling. And what that really raises is, okay, it's only part of the litigation. And in many ways, they're not making strategic litigation decisions. But they are responsible for saying, yes, we've found all the documents, that meet the court's orders in relation to discovery. But that's where it comes back to the need to coordinate the service. So you unbundle and you're able to access particular services more cheaply, and you may be getting greater expertise. But the lawyer that's actually running that piece of litigation, from the court's perspective, they're on the hook for that discovery. And so that's why you need that coordination, which in itself creates another cost. Now, I'm not saying it's a cost that would be anywhere near commensurate with what's being saved, but it's got to be understood that you do need to manage the process. And maybe that's an in-house lawyer that's doing it. Maybe it's the lawyer in the law firm. The way that litigation's currently conducted, it's the solicitor on the record. The solicitor on the record would come from the law firm. They would be the person that would have to make sure they did that coordination.